indeed honored to address this distinguished gathering as the chairman of this occasion and to bring the warm felicitations and full support of the federal government of Nigeria. The Chief Justices and senior members of the judiciaries of Ghana, Sierra Leone, the Gambia, Kenya, and Liberia extend to you the warmest welcome of the federal government of Nigeria. Your presence at this seminar is a demonstration of the trust that our sister nations have placed in this platform. This seminar has outlasted administrations, policy cycles, and economic turbulence, and it stands today as one of the most respected judicial learning and development fora on the African continent. I wish to make a commitment from this podium today. The Office of the Secretary to the Government of the Federation will actively support the follow-through of actionable recommendations that emerge from this seminar. The work done should not remain in this hall. It must find expression in policy, in legislation, in institutional reform. Celebrations of these 3 days contribute measurably to the strength of maritime justice in Nigeria and to the reputation of our great nation as a serious, credible, and competitive player in the global maritime order.
It gives me immense pleasure to join you today at the opening ceremony of the 18th International Seminar for Maritime Judges. It is particularly gratifying to note that this enduring partnership has continued for over 3 decades, providing our judicial officers with opportunities to engage emerging legal issues, exchange comparative experiences, and deepen their understanding of international maritime law and practice. The enduring motto of this seminar, Advancing Maritime Justice, Strengthening Global Trade, aptly captures the indispensable relationship between a sound legal system and a prosperous maritime economy. Maritime commerce flourishes where the rule of law is respected, contractual obligations are enforced, disputes are resolved fairly and expeditiously, and judicial decisions inspire confidence among investors and trading partners. Over the past 3 years, this administration has worked assiduously to lay the institutional, regulatory, and economic foundations of a thriving marine and blue economy. We have developed Nigeria's first ever national policy on marine and blue economy to provide a coherent framework for sustainable sectoral development. Infrastructure policy reforms and institutional development alone cannot guarantee the success of our maritime aspirations. They must be complemented by a legal and judicial system that commands confidence both nationally and internationally. One area deserving particular attention is maritime security. Although our collective efforts have significantly improved security within Nigerian waters, we cannot afford to rest on our laurels, particularly in light of the evolving security dynamics across the world. The prosecution of piracy and armed robbery at sea under the Suppression of Piracy and Other Maritime Offences (SPOMO) Act 2019, which domesticates relevant provisions of the United Nations Convention on the Law of the Sea, UNCLOS, and other international instruments such as the 1988 Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, requires continued judicial vigilance. The effectiveness of this legal instrument ultimately depends upon judicial interpretation and their consistent application in ways that deter criminality while safeguarding due process and the rule of law. Nigeria cannot aspire to become Africa's preferred maritime hub, while complex shipping disputes across continue to be routinely resolved in foreign jurisdiction through litigation or arbitration. I'm particularly pleased that this seminar continues to attract participants from our sister countries across the West Africa. Maritime law, by its very nature, transcends national borders. The challenges confronting the Gulf of Guinea, including maritime security, environmental protection, shipping regulation, fishery management, and cross-border commerce, require coordinated legal responses founded upon shared understanding.
The effectiveness of maritime legal regimes has direct implications for international trade, investment, food security, energy supply chains, and sustainable economic growth. No blue economy can attain its full potential without a legal and judicial system that inspires confidence. The pursuit of a sustainable blue economy must necessarily be underpinned by legal accountability. The administration of maritime justice is therefore strengthened when courts across jurisdictions engage one another, exchange ideas, and share experiences in confronting common legal challenges. Now my singular honor and privilege to formally declare open the 18th International Maritime Seminar for Judges.
A maritime dispute may begin with a vessel, a cargo, or a commercial agreement, but its consequences rarely end with the parties before the court. It can affect the movement of trade, the cost of goods, and the investor confidence and the competitiveness of an entire economy. That is why maritime justice matters. I acknowledge the visionary leadership of His Excellency, President Bola Tinubu, GCFR, whose establishment of the Federal Ministry of Marine and Blue Economy gave institutional expression to Nigeria's maritime aspirations. I equally acknowledge the Honorable Minister of Marine and Blue Economy, His Excellency Oyetola, CON, whose visionary, strategic, and reform-driven leadership continues to translate the President's aspiration into concrete policies, institutional reforms, and measurable progress.